Welcome to our continuation studying intentional torts. We are now moving into the phase of defenses and privileges of intentional torts, right? So this lecture is going to focus specifically on consent as a defense to intentional torts. Before we dive into consent as a defense to intentional torts, I want to talk about affirmative defenses. I know we mentioned it in class, but I want to make sure that all of the information is in one place so that you have access to it at one time. An affirmative defense is a legal argument that, if successful, even if the plaintiff can establish their prima facie case, the defendant may not be held liable if they are successful in proving up their affirmative defense. So this is what it looks like. Plaintiff sues, plaintiff goes to court, plaintiff proves up their prima facie case as it relates to whichever the tort it is that they are claiming, right? Does plaintiff win? Well, we're not done, okay? Just because the plaintiff has established their prima facie case does not mean that the case is over. If the defendant has pled an affirmative defense, that means that they've, in their responsive pleadings, have alleged that the plaintiff has consented, that's pled an affirmative defense. And if the defendant is able to establish by a preponderance of the evidence that's the same standard of proof, if they are able to establish by preponderance of the evidence that the plaintiff consented, then there's a real possibility that even if the defendant did or didn't do what the plaintiff said they did or didn't do, there's a chance that the defendant isn't going to be held liable. That's an affirmative defense. It has to be pled and it has to be proven. The defenses and the privileges that we are going to speak on as they relate to the intentional tort are all affirmative defenses. Great. With that bit of background, let's jump into a hypothetical. A, that is the gentleman that's throwing the axes, is throwing axes at B. That is the gentleman that's standing there with his hands by his side as A throws the axes. B sues A for the intentional tort of assault, right? B goes into court. B proves up their prima facie case and raises their hand in victory saying, I win, right? Intentional act created to cause this apprehension of imminent and harmful, et cetera, right? Are we done? Not so fast. Not so fast. If A has alleged or pled an affirmative defense, specifically the affirmative defense of consent against B, and if A is able to establish the prima facie case of consent, right, there's a real possibility that even though it's clear that A is throwing axes at B, I think it's pretty clear that any reasonable person is going to feel apprehensive in that situation. I think like minds can agree that we probably got a really good case against A for the intentional tort of assault. But if B has consented, then there's a real possibility that A is not going to be held as liable for the assault. Essentially, for those of us who are more visual, consent, when successfully pled and established, acts as sort of a cape that covers the defendant, right? So just think about it. Did I do something that may put me in a position to be liable for an intentional tort? If I did I have the plaintiff's consent to do it? And if I had the plaintiff's consent to do it, then this cape of protection called consent may save the day, right? So when you're thinking about consent, think about it like that. I'm going to take a second. I want you to think about that. Get your visual if my visual doesn't work. But really, consent's pretty straightforward. And I want you to think about it as being pretty straightforward. Okay. Consent can act as a powerful defense, right? Think about this cape that saves the defendant from liability. Consent can act as a powerful defense against the following intentional torts. You got them all up there. We discussed 7 intentional torts, and 6 of those intentional torts are open to consent being a defense, not the intentional tort of intentional infliction of emotional distress. This is a good multiple choice question. So pay attention to this, right? Why would intentional infliction of emotional distress not be a tort that would be subject to consent? This is what I talk to you all about pretty regularly. Learning versus memorizing, right? As adult learners. Memorizing, sure, you could probably memorize the 6 that are applicable to consent as a defense, right? And the way to do that is to remember that we've got 7 of them. 1 of them doesn't work. So instead of remembering the 6, you could memorize the one that doesn't work. Yeah. Easy peasy, right? Until you got so much in your brain that there's not enough room for another piece of just strict memorization. Understand the purpose of these rules of law. Understand what they're intended to do. Understand how they work. And then you don't have to memorize, right? You can rationalize your way to the correct answer. Why would the intentional tort of intentional infliction of emotional distress not be subject to consent as a defense? Think about it. What is the intentional infliction of emotional distress? Number 1 is emotional, right? So the intent of consent works much better when we have something physical involved, unlike emotion, but that's really not the best rational reason. What's the best rational reason? Intentional infliction of emotional distress requires, right, outrageous or extreme behavior. Who in their right mind is going to consent to someone treating them with outrageous or extreme behavior, right? Who's going to do that? Nobody's going to do that. Who's going to consent to someone treating you so awfully with their outrageous or extreme behavior that it results in you severe emotional distress? Nobody's going to consent to that, right? So it just makes sense that as we speak of the 7 intentional torts that we discussed, intentional infliction of emotional distress is not one where consent can be served or could be utilized as a defense. Great. What is consent? You know who I am. You know where I expect you to go when it comes to the rule of law. I expect you to go to the horse's mouth. I want you to go to the rule of law, right? If you are in a testing situation where the test provides a statute. Where are you going to go for the rule of law? You're going to look at the statute. But being part of a UBE universe, Unified Bar Exam universe, very rarely are you going to get specific law from one jurisdiction because there's so many jurisdictions. So what are you going to rely on as your rule of law? The restatements of torts, right? Restatement, second of torts, section 892. Consent is the willingness to allow intentionally tortious behavior to be done to you. Consent is the willingness to allow intentionally tortious behavior to be done to you. You'll notice in this video, I'm relying on the restatement second of torts. Why am I relying on the restatement second of torts? When your casebook, your course book, the book that you have for this course speaks to the restatement third of torts, because the restatement third of torts that the course book refers to is the fourth draft. It's a draft. It's the fourth draft of the restatement third of torts that was completed in 2019. So what does that say? That says that it's not in its final published state, which means it may change. And I don't want to rely on something that's subject to change. So that's why I'm relying on restatement second of torts 892. Okay. Restatement second of torts 892A, as it describes the effect of consent, I believe gives a better definition of consent. Okay, so what is 892A, restatement second of torts say? Consent is one who effectively consents to the conduct of another, that's the intentional tortious conduct of another, right? That is intended to invade, right, their interest, their protection, right, has to be of a certain status and their ability to form that consent. So what does that status include? Number one, the person giving consent has to have the capacity to give the consent, right? And if they don't have the capacity, then the consent has to be given by a person who's empowered to give consent for that person who doesn't have the capacity, okay? The consent has to be given to a particular conduct, right, that is exactly or substantially the same as the conduct that they bear, right? Conditional consent or consent that is restricted has to be treated as the limitations are provided, right? With the understanding that if the actor, that in this case is the defendant, exceeds the consent is no longer effective, right? And once the consent terminates, the protection, the effectiveness of the consent terminates. So let's go back one slide. What do I know about the person who's giving the consent? They have to express a willingness to allow themselves to be the recipient of intentionally tortious behavior. Has to be willing, right? Has to be voluntary, right? Excuse me. What else do we know? We know that the person who's giving consent has to have the capacity to give that consent, okay? What else do we know? Well, let's look at it. Let's go at it from a different perspective. We're covering the same information, but we're going to cover it from a different perspective. When we say that the person who's giving the consent has to have capacity to give the consent. We're talking specifically about three things. Excuse me. Let me pause for just 1 second. All right, let's see if we can go forward. The requirements for consent. The person who is giving the consent, right, or the person who's giving consent on behalf of one who can't give consent must have the capacity. What do we mean by capacity? They must be of legal age. They must have the mental capability, and they must have a sober state of mind. Generally, we're looking at minors who can't consent, which means they would have to have a person stand in their stead. People who have mental health disabilities do not have the capacity to consent. And people who are being impacted by drugs or alcohol are said to not have the present sense of mind to consent. So that's what we mean by capacity. We've already talked about the willingness, right? The voluntariness, the voluntariness of it. What do we mean by voluntary? The consent must be given willingly. The consent must be given absent duress. The consent must be given absent fraud. And the consent must be given absent mistake. Yeah. If the situation involves a medical consent, then there's going to have to be established that the person who gave consent was, air quote, informed, or in the lack of an informed consent for medical procedure, the consent will be presumed if there is a life-saving emergency involved, okay? And lastly, just as important as all the rest, the consent must remain within the scope that it's given. The consent must remain in the scope that it was given. So when you're looking for whether or not consent was actually provided, look to see, did the person who gave consent have capacity? Look to see if the person who gave consent did it voluntarily. If it's a medical matter involved, look to see if there are facts that establish that the person who gave consent provided it based upon information that they were provided, right? It wasn't just a blind consent. And if there wasn't an informed consent and there's a medical issue involved, look to see if that medical issue was an emergency. Was it a life-saving event? Yeah. And then if you can establish capacity and if you can establish willingness and if you can establish informed consent or an emergency, you've got to make sure that the conduct, the action that was done was within the scope of the consent. And really, we could actually stop the video there because that's going to be enough to get you through a multiple choice question or even a hypothetical that talks about consent. But we're not going to stop there. I know, I got you. We're not going to stop there. While I've got your attention and we're talking about consent, let's talk about the different categories of consent. Where am I going to ask you, did you go to look at this rule of law? Did you look at the restatement? Restatement 892B. Restatement 892B. You've got several categories of consent. You have actual consent, which can either be expressed or implied. You have apparent consent. You have presumed consent. And then you have consent that is connected to emergency situations. So let's look at the actual consent. 892B, actual consent. A defendant is not liable for the defendant's otherwise intentional tortious conduct if the plaintiff gave legally effective consent to the conduct, right? And we just talked about what is legally effective consent. That is capacity. Remember, you want to go back a couple of slides? I know you're probably taking notes, but let's go back a couple of slides. That's capacity, that's voluntary, that's informed medical consent. In the absence thereof, there's a life-saving emergency. And the conduct that was done within the limits, was done within the scope of that consent, right? So we have actual consent. We have, you know what? Let's go ahead and finish talking about actual consent. Actual consent. A plaintiff's actual consent extends to the conduct by the defendant that is not substantially different in nature from the conduct that the plaintiff is willing to permit. What's a much easier, much cleaner way of saying that? If I consent to one type of conduct, for instance, I consent to get into a boxing ring with you because we are both professional boxers and we get into the boxing ring and you hit me in the face. Well, I didn't consent to get hit in the face, but I did consent to get into the ring boxing with you, understanding that being hit in the face is part of is within the rules of engagement. Yeah. However, let's say that instead of just strictly boxing by the rules of engagement, you decide to flip me over your shoulder on the floor, get me in a guillotine, and then try to make me pass out, right? Lose consciousness. I didn't consent to MMA. I consented to boxing. Yeah. So when the rule says that the conduct has to be the same or not substantially different in nature, that's what they're referring to. Okay. Limits or conditions. When a plaintiff places a condition on her actual consent that limits the consent, right, as it respects to time, place, or otherwise, the consent is only effective within those legal constraints. I consent to get into a boxing match with you. We're going to go 13 rounds. The last bell has dung. We are over. It's fun. It's been great. I'll see you next time. We're walking out to the parking lot to get into our respective cars, and you want to continue boxing. I didn't consent to do that out here. I consented to do that in the ring as a professional where we're both getting paid. I didn't consent to a street fight, right? So limits and conditions. If limits are placed upon the consent, the limits must be adhered to. If the limits are exceeded, that is going to be said that the actor has gone outside of the scope. Okay. Revocation of consent. A person who gives consent can revoke that consent at any point, yeah, provided that the revocation is clearly communicated. That's where lawyers get to practice law, because what does that even mean? Well, I'm going to tell you what I always tell you, which is the reason most people don't like lawyers. It depends, right? Always, right? It's fact driven. It's fact driven. You've got to look at your facts. Can a party consent to a crime, hmm, I'm going to consent to this unsanctioned MMA battle in your backyard when I know that this type of mutual combat is illegal. Can I give that consent? Well, of course I can give it, but does that consent have any legal effect? The jurisdictions are split on it. What does that mean to you as a law student? Means that probably not going to get tested on it, right? Because we, studying from a UBE perspective, have lots of jurisdictions that have spoken to this. And there's no way to capture all of them in a general sense. Yeah. So my advice is there's going to be enough to test on consent such that you don't have to add consent to a crime on your list of things to study. What about past conduct? Consent does not exist in perpetuity. So consent for something right here, right now, today, does not generally continue into the future, right? So just because I had consent to do some conduct or behavior to you today doesn't mean that I can rely on today's consent to do the same intentionally tortious conduct of behavior to you in the future. So that's not how consent works. You need to look at, do I have current consent? What about mistake? Actual consent given by a plaintiff that is based upon a substantial mistake regarding the nature of the invasion, right? Regarding the harm that's expected, or regarding the defendant's purpose in engaging in the conduct, right? Is valid unless the defendant caused the mistake by fraud or an affirmative misrepresentation. Best example of that is the DeMay. I put DeMaya here, but it's the DeMay case versus Roberts. That's where you had the doctor, guess he was an OBGYN, made a house call to a woman who was in active labor, getting ready to give birth. He had an assistant. He introduced this assistant, but he did it in a way without any clarification that the assistant was not a medical doctor. We're talking about 1881. The gentleman who was the assistant was an unmarried non-professional, right? So the woman in labor with her husband gave consent for the doctor and this air quote assistant, not knowing that he wasn't a doctor, not knowing that he was an unmarried man. And during those times, the social norms were just, that wasn't acceptable. I don't even think that would be acceptable nowadays. And so while they gave consent, yes, sure, okay, the doctor could not rely on that consent because there was an affirmative misrepresentation. Okay. Duress, well, that makes sense. If I have physical force against me, or if I have threats that I believe against me, any consent that may result from that isn't going to be valid consent, right? Let's talk about capacity. I think we've talked about it. I put an additional slide in here on capacity because this is part of the process that you're going to have to work yourself through methodically so that you don't get tripped up. Because you may say, oh, Well, this person gave consent and there was no duress and it looked like it was voluntary and the conduct was done within the scope. So yeah, boom, yes, that's consent. Look first to the capacity. Look first to make sure that the person who's giving consent has the ability, has the capacity to give consent. Okay. Don't skip the analytical steps. You got to follow the steps. Apparent consent, we're going to look at 892C, that's restatement second of torts. A defendant is not liable for otherwise tortious intentional conduct if the defendant reasonably believes that the plaintiff consented to the conduct, even if the plaintiff didn't. We talked about this a little bit in class yesterday, and I said, wait, that gets a little sticky because now I'm trying to figure out what does the defendant think the plaintiff thinks. And we know if at all possible, we try to stay far outside of lanes of speculating not only what people think, but especially what people think about what other people think, right? It just gets dicey. If you want some more information about apparent consent, go to Restatement Second of Torts, section 892C, where they have some illustrations, okay? Continuing with apparent authority, apparent consent, apparent authority, I'm sorry, continuing with apparent consent. Apparent consent looks at the defendant's reasonable belief of what a reasonable person would do. Again, what does the defendant believe a reasonable person would do? It starts to get a little sketchy when we jump into that world of trying to figure out what we think somebody else thinks. An example that our course casebook gives is the case of O'Brien v. Kennard, 1891. This is the case where you have the plaintiff coming over to the United States. That was during a time where the flu was rampant and was doing great damage. And in order to come into the States, either had to show proof of inoculation or you had to be inoculated before you got off the boat, right? You've got a plaintiff who's on the boat who understands that she's either going to have to show proof of inoculation or she's going to have to be inoculated. She gets in the line where all the people are standing. I think there were 200 or so women in line, all waiting to be checked for either being inoculated or to get the inoculation, right? She stands in line, she waits, she's watching other people get inoculated. I think our book says she's less than 15 feet from the doctor who's given the inoculation. She sees what's going on, right? She's witnessing everything that there is to witness. When it's her time, she tells the doctor, I've already been inoculated. The doctor looks at her arm and doesn't see the mark and says, you need to be inoculated. She lifts up her arm, she gives him the arm, and he inoculates her. Well, later, she believes that the vaccine was contaminated and she sues based upon a theory of the intentional tort of battery, right? And the court, in essence, says, well, what is a defendant, the doctor, what is his reasonable belief, right? The doctor, of what a reasonable person would do if they get in line, they wait in line, They stand in line. They watch the procedure. They sit down in the chair. They give the doctor their arm and they get inoculated, right? What the defendant, what would their reasonable belief be that a reasonable person would do? Well, that's apparent consent. I actually think that this is a better case for implied consent, right? Because it wasn't expressed by words or writing, but it was expressed in her actions. Don't get caught up right here with the tomato and the tomato. Is it implied or is it apparent? Did we have capacity? Yeah. Did we have the action remaining within the scope, right? Do you see what I'm trying to say? You need to look to see, did it appear to be voluntary? Did it appear to be willing, right? Are there any facts that support that even though she said, I've already had a vaccination, she sat in the chair after standing in line, after watching countless women get inoculated? She gave the doctor her arm. There was nothing in the facts that indicated that she was duress, right? There was nothing to indicate that there was a threat. There was nothing to indicate that there was a show of force. There was nothing to indicate that she wasn't willing. And in the absence of those facts, we've got to take it for what it was, right? Does that make sense? All right, let's keep moving. We are almost done because, as I said, consent is really pretty straightforward, okay? Let's look at presumed consent. What do we want to say about presumed consent? Let's check it out. The actor is justified, right, under prevailing social norms. Ooh, here we go, right? The actor has no reason to believe that the actor right now is the defendant, right? This is going to be the person who's going to be asserting the defense of consent. The actor is justified under prevailing social norms in engaging in the conduct, and the actor has no reason to believe that the person would not have actually consented. The defendant is not liable for otherwise tortious intentional conduct if, under prevailing norms, the defendant is justified in engaging in the conduct in the absence of the plaintiff's actual or apparent consent. Yeah? Need more information? Where am I going to send you? 892 comments, restatement second of torts. Let's get to our last category, emergency. That's going to be the Moore v. Williams case, 1905. Emergency. If there is an emergency where we are talking about life-saving efforts, the benefit is going to go to the doctor who saved the person's life. The benefit is going to go to the doctor who saved the person's life. Could you get in under presumed consent, right? Because remember, let's go back to presumed consent that says that social norms, what would a reasonable person want? Well, you would think that a reasonable person would want for whatever contact, potential battery, whatever contact that needed to be done to save my life, right? So could the Moore v. Williams case actually be settled under the category of presumed consent? It could. However, that's not your strongest theory. right? Go with your strongest theory first, make any secondary theories your alternate. What's the strongest theory for medical professionals if it's a medical emergency, right? Moore v. Williams was not a medical emergency. Moore v. Williams, I look at your right ear, you've got a tear that needs to be surgically fixed. Oh my gosh, please fix it. Yes, I'm going to sign the consent. I think that's wonderful. I think that's great. Don't trust you. I want my family physician to be there. Oh, sure, your family physician can watch the surgery, not a problem. Put you under. We start the surgery. I look at your right ear again, and I'm thinking, you know what? I couldn't really get a good look at your left ear because at the time that you came in and I tried to look at your left ear, there was some object or there was something in your ear and I really couldn't see. But now that we're in the surgical suite, I've got better lighting, better instruments, better tools. I've got you in a better position where I can really see. Let me see what's going on with your left ear. Oh, my goodness, it's your left ear. That's really going to be the problem. So since you signed the consent, I've explained to you the procedure. We're going to do the exact same procedure that we would have done on your right ear. We're going to do the same procedure that we would have done on your right ear, on your left. Your doctor, your family doctor, who's been your doctor all your life is here. Hey, doc, come on over, take a look. See what I see. Let's consult. What do you think? Yeah, I'm going to go ahead and do this operation on the left ear. Doc, you good with that? Cool. You good with that? Nice. Come out of surgery. I explained, took a look at your right ear, and it actually looks like it was starting to do some healing. So we didn't want to put you under any of the trauma of that because your left ear was really the problem. Now, I wasn't really able to look at your left ear when you came in, but we fixed it and it went spectacular. And you should be great to go for the rest of your life. Yeah, I'm not satisfied. So she sued him for intentional tort of battery, and she won $14,000 back in 1905, which in today's money is a heck of a lot of money, right? What's the problem? We talked about this in class. He didn't have the medical consent to operate on her left ear. And while maybe it was a situation of hearing loss or permanent hearing loss or whatever the worst of that situation could have been, it wasn't life-saving. And so the doctor doesn't get the benefit of the emergency exception. That's Moore v. Williams. And that, ladies and gentlemen, is consent. Have any questions? Think about it. The video was probably about 45, right? Roughly the time for a class period. Rewind it, look it over, make some notes. If you've got some questions, write them down. Let's talk about the questions tomorrow on Wednesday, the 23rd. When we get to class, if there's no questions, we are going to keep moving forward and we're going to go into the defenses. I don't believe that we're going to be able to cover self-defense, defense of others, and defense of property all in one setting. So we're going to start with self-defense. So make sure that you're ready to discuss self-defense, because if there's no questions on consent, we're going to keep on moving. Have a great evening, and I look forward to seeing everyone tomorrow.